This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an insurer must be careful when issuing a waiver, and why the waiver of two very specific rights does not infer, and no court will infirm, a waiver of all rights. To recover, therefore, an appraisal award, an insured must actually repair or replace the damaged property, and hurricane repairs must be completed before the running of a statute of repose. In this case, the policy had a 2-year statute where the repairs needed to be completed within 2 years of the issuance of the policy, which was waived. But the state of Florida, where the hurricane damage occurred, also had a 5-year statutory waiver as statute of repose, which means that they couldn't sue or proceed with a suit after the running of 5 years from the date of the claim. Cresthaven, a condominium association, appealed the district court's denial of its motion for relief from the court's order dismissing without prejudice Cresthaven's suit against Empire Indemnity Insurance Company, and for leave to file a supplemental complaint. In Cresthaven v. Empire, the United States Court of Appeal for the 11th Circuit on August 7, 2024, reviewed and resolved the dispute raised by Cresthaven. As a condominium association, it purchased a commercial property policy from Empire for a period covering March 17, 2017 to 2018. On September 10, 2017, Hurricane Irma struck the state of Florida. Cresthaven was damaged and timely filed a claim with Empire for property damages sustained in the storm, which Empire denied on April 19 of 2019. Cresthaven's complaint, filed on July 15 of 2019, sought a declaratory judgment that it did not breach its post-loss duties, as well as the enforcement of the policy's appraisal provision and damages for breach of contract. Over the next 3 years, the parties conducted an appraisal, and Cresthaven received 2 awards for property damage. Empire filed a motion to dismiss eventually for lack of subject matter jurisdiction, arguing that Cresthaven's case no longer presented an actual case or controversy under Article 3 of the U.S. Constitution. The court granted Empire's motion on March 24, 2022. The dismissal order required that Cresthaven needed to first identify an applicable law or ordinance that, if enforced, could result in a loss in value to the undamaged portion of the building or an increased cost to reconstruct any portion of the building, whether damaged or not. Second, the applicable law or ordinance needed to be enforced. And third, the applicable ordinance or law must have resulted in the aforementioned loss in value or increased costs. Cresthaven failed to satisfy any of the 3 preconditions. The court therefore dismissed Cresthaven's claims for failing to present an actual case or controversy. Cresthaven diligently commenced and completed repairs for several of its structures, and never completed repairs or completed them timely to recover benefits under the replacement cost coverage under Empire's policy. Empire effectively invoked the 5-year statute of repose for property insurance claims under Florida Statute Section 95.11(2), close paren, E, close paren. Empire, the court noted, never waived its right to invoke the statute of repose. Without evidence that Empire represented that it would not invoke that statute, the 11th Circuit could not conclude that the district court abused its discretion in declining to attribute bad faith to Empire's communications about adjusting the claim with Cresthaven after dismissal. Empire's written waiver was very specific and waived only the, quote, as soon as reasonably possible, close quote, and the 2-year deadline with respect to repairs, the temporal limitations that appeared in the policy itself. Empire's July 8, 2022 letter invited Cresthaven to complete repairs and submit requests for payment. The fact that Empire did not invoke the 5-year statute of repose after its expiration merely indicated that Empire intended to exercise its rights under the policy provisions in the law, which intention was apparent from the very inception of Cresthaven's claims. Empire's waiver of 2 very specific rights is not a basis on which to infer waiver of all rights, and the policy provisions required Cresthaven to perform the work and identify the relevant ordinance before seeking reimbursement. And since the district court noted that it was too late, the district court could still have granted the motion and should have. In my opinion, waiver is a legal concept that allows parties to agree that certain conditions of a contract of insurance will not apply as long as it is knowingly made without coercion. Empire waived 2 rights provided to it in the policy. That was all it waived, nothing more. And it certainly did not waive the statute of repose, which, when it expired, destroyed the entire lawsuit and arguments of Cresthaven. An insured should never sit on its rights. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will have access to the more than 4,800 blog postings. You can also subscribe to these videos on YouTube and on rumble.com. They're free, and you can make comments of them as you wish. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, or insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.